All right, folks, we're going to go ahead and get started. On behalf of the Constitutional Law Center, I want to welcome you to this Supreme Court review and preview. We are also delighted to have as co-hosts the American Constitution Society and the Federalist Society. And we've got three great panelists to talk about the past and upcoming terms. All three served as law clerks at the Supreme Court. All three have extensive experience litigating at the Supreme Court. We have Erin Murphy, who is a private litigator with a boutique appellate law firm called Clement Murphy. We next have Mike Mongan, who is the Solicitor General of California, and then finally, and also an SLS grad, and finally our own Easha Anand, who's the co-director of the Supreme Court Litigation Clinic. We're going to have a couple of students kick off questions and then open it up to general audience questions if you come down to the microphones and line up after. And then we'll end with a reception outside in the courtyard. So without further ado, I'll turn it over to Easha.
Well, thank you, Judd. Thank you all for being here. Thank you to everyone for hosting us. And it is always an honor to be on a panel with Erin and Mike, so thank you guys for being here. I thought I'd open by talking a little bit about Justice Barrett, now that we've had kind of 4 terms of data points about her. So a few themes I kind of want to highlight, and then I'm really curious to hear what Erin and Mike have to say. The first is kind of, she's working out her feelings about the use of history kind of in real time before us. So a few examples of that. The first is sort of how she talks about post-ratification history. That is, to what extent things that happened after the time of the founding can shed light on the meaning of the Constitution. So in Rahimi, which was last term's big Second Amendment case, which we're going to talk a lot about in this panel, we see her expressing real skepticism about the use of that history and positing some limits on its use. But a few terms ago, she joins a concurrence by Justice Kagan in a case about the constitutionality of the funding structure of the Consumer Financial Protection Bureau, where Justice Kagan sort of says, it's not just the founding era history that matters, it's all the stuff that has happened since the founding, and kind of chastises the majority for not relying more on that kind of post-founding history. More generally, I would say she's maybe a little more skeptical than some of her ideological fellow travelers about the use of history in every case. So some examples of that, we see her kind of taking some of her colleagues to task. Sorry, maybe, is this any better? Can folks still hear me? Okay. We see her taking her colleagues to tasks, sometimes for their use of history. So I'm thinking of a confrontation clause case called Samia, where she says, I agree with the bottom line, but the historical evidence is, quote, beside the point. That was not how we should have resolved the case. This past term in a case called Vidal versus Elster, which is about whether the trademark office can refuse to trademark the phrase Trump too small. So for folks who don't quite remember this is a phrase from a debate, a reference to an exchange between then candidate Trump and Marco Rubio in a Republican primary debate many years ago. The majority says it's fine for the trademark office to refuse to trademark this. Justice Barrett agrees, but again, she says, the majority's claim that history and tradition settles the constitutionality of this clause is wrong twice over. The court's evidence does not establish the historical analog. And more importantly, the court never explains why his hunting for historical forebears on a restriction by restriction basis is the right way to analyze the constitutional question. So again, real skepticism of how the court uses history. The second theme I maybe want to highlight before I open it up and want to chat about this with Erin and Mike a little bit is we're sort of seeing a fairly deeply, I would say, kind of minimalist set of instincts emerge from Justice Barrett, at least in maybe low ideological salience cases, and maybe even in some that I would have thought of as high ideological salience. So the example I'm thinking of from this past term or two is a case called Sheets, which is a case about the taking clause. And so the lower court had basically said that legislative enactments, that is when the legislature passes a law, that's exempt from scrutiny under what's called the takings clause, which is a restriction on whether and when the government can take your property without compensating you. Justice Barrett says no, but we're not going to say a word about anything else but how you analyze that. And we see 5 of her colleagues writing separately to basically be like, you should have resolved some other piece of this case. Now, maybe that's, a function of just being in the majority. She's trying to keep the band together. But we see some better examples maybe in some of the Trump cases from this past term. So Trump versus Anderson, we'll talk more about this case, but this was the case about whether Colorado could disqualify Trump from the ballot based on his participation in the events of January 6th. The majority says, no, Colorado can't do that, and potentially, federal legislation is the exclusive vehicle for disqualifying a candidate under this provision. Justice Barrett says, why did you decide that second thing, right? It's a complicated question we should not weigh in. Same thing in the kind of Trump immunity case. She sort of says, look, majority, I agree with you, but I don't know why you're talking in terms of immunity when there's a simpler and narrower way to resolve this question. So maybe I'll pause there because I'm curious to hear Erin and Mike talk about their thoughts about Justice Barrett for the past few terms. But those are sort of 2 of the big things I've noticed about her jurisprudence.
Yeah, so a few thoughts. I think she is already an extraordinarily consequential justice and is likely to be one of the most consequential justices of our lifetimes for the next 20 or 30 years. And you get the sense that in her own modest way, she sort of appreciates that. And both in her questioning from the bench and in her writing, she is thinking really hard about rules and doctrines and methodology, often thinking beyond the current case. And you can just imagine her sort of trying to predict out, am I going to be happy with this precedent if I'm the median voter in a case 15 or 20 years from now? And I think, originalism this turn, both in Rahimi and the separate opinion in Vidal, show her really wanting to do some thought to try and make that methodology kind of workable and sensible. I guess another one that I would add into the mix is her writings and her presence on issues related to the emergency docket. Her dissent in Ohio against EPA, where in addition to breaking with the other conservatives on the underlying APA issue, she sort of takes them to task for providing emergency relief in a case where there is an extraordinarily complicated record and a lot of arguments that are underdeveloped, and sort of cautioning the court against rushing in on the shadow docket. And I think, joining in, is it Labrador, a similar separate opinion expressing some caution about when the court should move on the shadow docket. So I think she's just a fascinating justice to watch, and we'll look forward to watching her on these issues and others in coming terms.
So I very much agree that she's been a fascinating justice to watch, in large part, in significant part at least, for the reason Easha says, which is she's just doing a lot of this in real time out loud, and we get to hear and see her thought process as she's kind of working through cases. And I think she's a really interesting justice because I take her to be asking questions just like in a very genuine, I'd like to know the answer to help me figure this out way. Whereas, with a lot of them, the longer they're there, a lot of the questions are really designed for somebody else to hear them, not to hear what the advocate has to say. And when you watch her, it's very clear that she's just like, no, this is what's on my mind, and this is what I'm thinking about. But I do want to take a little bit of a step back and just kind of take it as an opportunity to think about, one of the common questions people have about this court. Is it a 6-3 court? Is it a 3-3-3 court? How do we think about all that fitting together? And I think she's an important piece of the puzzle because, I think you'd have to look at this court and see that we have 3 justices who are kind of in the majority the most frequently, and it's the ones who you kind of think of as being in the middle, the Chief Justice and Justice Kavanaugh and Justice Barrett. They're with them a lot this year, and they are kind of the 3 that are by far the most likely to not be completely aligned with all conservative justices in any given case, and to have some different coalitions, whether it's with all the liberals or with kind of a mix of folks, but you're more likely to see them. But I do think, and from what I've seen so far, I think that Justice Barrett is animated by something a little bit different from what I think of the Chief Justice and Justice Kavanaugh is animated by. The Chief Justice is an institutionalist, and I think his minimalism is driven very much by thinking about the way the court is perceived, thinking about, helping, how will the public kind of get where we're going? Have we helped them get there? There's been for years the signature move of the Roberts Court in the early years was to kind of get a little bit closer in this case and a little bit closer in the next case and go all the way in the third case. So you're kind of building to overruling a precedent or something like that. And there's just, you can tell from the Chief Justice's writings, this sort of felt need for to be sure people are kind of perceiving the way, it's not, I don't think that leads him to sort of change his votes, but I think it does impact how he thinks about particular cases and how broadly or narrowly they can and should be resolved. And then you see some of the same instincts from Justice Kavanaugh. I mean, the two of them are year in and year out, the two who are closest together on the right side of the court, and also typically the ones who are in the majority of the cases across the board. And Justice Kavanaugh, you can see a lot of his questioning and his opinions are very clearly designed to help the public appreciate how he's thinking about what the court's doing. Sometimes he'll ask advocates these questions that are just like, so if we rule for you, that doesn't mean such and such, right? And I mean, he knows the answer. Everyone knows the answer. He's asking those questions for people who aren't, who to try to push back on kind of knee-jerk media reactions to cases and get people to appreciate subtleties about them. But it's part of kind of a public dialogue. I don't think that's what it's about with Justice Barrett. I don't think she's kind of like an institutional minimalist, and I don't think it's quite that she's just like a moderate. I think she's jurisprudentially cautious. What you seem to see from her is she's thinking in every case about, if I take this position, if I accept this position here in this case that's about this issue, what does that mean for this issue that's coming down the pike and this totally different area that's coming up next? And like, what is the long game of committing myself to this right now? And I think if she's not sure, if you haven't kind of persuaded her, and I try to think about this from the role as an advocate of what you need to do, you think about what does it take to persuade certain justices, and they seem driven by different things. And I think for her, like, there is this sense of, I want to know, if I'm going to take a big position, I want to know where it's going and feel comfortable with it. And if I'm not sure, then I'm going to take a smaller position for now, or I might look for a way out of the case and a way out of dealing with this till I feel like I'm comfortable with where I'm going. And I just think that's like a little bit different way. To me, that's not the same kind of like institutional minimalism. And I think there's a little bit of a mistaken sense that it's driven by sort of like she's just like a moderate. I mean, she ends up in the middle on some things, but let's not forget she is the nominee who said, my jurisprudence is Justice Scalia's jurisprudence, and she hasn't really deviated a ton from that while she's been up at the court. So it's early years still with her, and it's really interesting to watch, but that's my sense, both of kind of where she is and how all of that fits together for purposes of thinking about, kind of the 6-3, 3-3-3, 5-4, what exactly is sort of the dynamic that we're dealing with this court at this point.
Yeah, and at the risk, Morgan is going to kill me because I'm going to go over in our very first segment. I have one thing to say that made me think about, and then I promise to stick to the time for the rest of the session, which is I feel like, Erin, that actually explains a little bit about Justice Barrett's kind of approach to stare decisis, which has been a little bit puzzling or interesting to me. So let's set aside Dobbs for a second, but she was the justice who, before getting on the court, wrote this article, Due Process and Stare Decisis, where she basically says, look, stare decisis maybe creates this due process problem, right? Like, if Erin sues Mike and Erin loses because she makes a bad argument, like, why should that bind Easha when Easha later raises the same claim, right? She's sort of deeply skeptical in her writings before getting on the court. But once she's on the court, there are obviously some really high-profile counterexamples, several of which we'll talk about during the session. But I think about in the sort of lower political salience cases, there's a case from this last term, Munoz, which is a substantive due process case about the rights of an American citizen in her non-citizen spouse's visa issuance. Like, if Justice Gorsuch or Justice Thomas had gotten that opinion, not only would they have rejected the claim, they would have done it, they would not have dutifully kind of gone through the tiers of scrutiny, which she does, right? Justice Barrett writes the opinion. She does a very kind of traditional Justice Kennedy style, here are the tiers of scrutiny and here's how this plays out, in a way that I think a lot of the other folks that I think of as being on her wing of the court would not necessarily do. I'm thinking of there's a case Fulton from a couple terms ago where a lot of justices are sort of looking for an opportunity to overrule some foundational precedent about how the free exercise clause works. And she writes this concurrence where she's like, we don't have anything better to replace it with yet. Like, let's just wait and see before we decide to jettison this test. And so I think caution is a good kind of through line for all of these pieces of the puzzle, that at least in the kind of medium, high to low political salience cases, she's got this real note of, I don't want to jettison any existing legal infrastructure, even the sort of legal infrastructure I surely disagree with, unless I know it's coming to replace it.
So I think I'm up next, and I will try to briefly, Morgan, discuss one other narrative of the 2023 term and try and interrogate how fair it is. And that narrative is a sense that the Fifth Circuit might be a little bit off the rails and that the Supreme Court is spilling lots and lots of ink in reversing or vacating the Fifth Circuit. So first, is this accurate? And like a lot of things, I think the answer is yes and no. In fairness to the Fifth Circuit, if you look at things in percentage terms, they did better than a lot of other federal circuits. 5 or 6 federal circuits had higher reversal rates. And they were affirmed in some very important, high-profile, consequential cases. I think SEC versus Jarchese is probably the most prominent example, but also Cargill, the bump stock case. On the other hand, the Fifth Circuit was reversed or vacated by my count in 8 of 11 merits cases, and that's a bigger number, I think, than any other circuit by a fair amount. And from where I sit, that number included some, I think the technical term is some real doozies, where some Fifth Circuit panels kind of got out over their skis as to jurisdiction and or the merits, and the Supreme Court had to grant review and fairly overwhelmingly reverse. I think I would include in that list Alliance, the Mifepristone case, the Biden administration social media injunction case, Murphy, the big Second Amendment case, Rahimi, and the CFPB funding case, most of which we will discuss later today. So, by any measure, it was sort of a rough year for the Fifth Circuit at the Supreme Court. So what does this tell us, if anything, about the modern Supreme Court? I have heard some try and spin this as evidence that the modern Supreme Court is actually a moderate court, is not that conservative. I'm not personally persuaded by that. And I think it kind of goes back to a point that Erin was making. I think if you squint at a number of these cases, a lot of these were fairly novel, aggressive, sort of new, pushing the envelope conservative theories. And you see that 3-3-3 model really in play in that type of case where generally all of the 3 justices at the center of the court are not willing to go along for the ride, but the Fifth Circuit often does pick up several votes or at least one vote from the 3 most conservative justices. I don't think that same model necessarily applies in a lot of other cases coming through this court. I think when it comes to overruling affirmative action, overruling Roe, Chevron, sort of enshrining broad presidential powers in the Constitution, this looks a lot more like a 6-3 conservative court with individual justices taking some different approaches, but generally being pretty unified on the more conservative wing. And I think that's probably how history is going to look at the court because of the prominence of those cases. I guess just briefly a word on what does this tell us, if anything, about what's next for the Fifth Circuit? I've heard some speculate that perhaps after the 2023 term, the Fifth Circuit might sort of rein things in and be chastened. We'll see. Color me a little bit skeptical. It sort of brings to mind this, quote from the late Judge Reinhardt of the Ninth Circuit, who was once questioned about his own very high reversal rate, and he said something to the effect of, yeah, well, it's high, but they can't reverse me in all of my cases. So I will close and note that there are already a couple big Fifth Circuit cases up at the court. There is Vanderstock, the ghost gun case, which has already been argued, and then Free Speech Coalition, a First Amendment challenge to a Texas law addressing restrictions on adult websites. So we may have some more data points about how the Fifth Circuit fares this term within the coming months. And I'm really interested to hear Erin and Easha's thoughts about the relationship between the Fifth Circuit and the Supreme Court and what it means.
Yeah, look, the Fifth Circuit is, I mean, there are several judges there who are just, they're incredibly aggressive in pushing the envelope. They are, they are accepting the arguments that we might see if we had like 5 Justice Thomases on the court. As I often say, to clients and people, like, we don't. So you have to be a little careful because it's all well and good to go press really aggressive theories in a favorable forum and get a win. But if you get a really aggressive win, you have to be able to defend it. And if you don't, and we'll talk a little bit about this in some of the cases we talked about today, it could really backfire and you could actually end up making bad law, not just not making good law that you're trying to create, but making bad law by virtue of kind of setting a case up. And I think it's interesting that if you look at the 2 kind of highest profile Fifth Circuit cases that were affirmed, the bump stock case, I mean, like, that's a traditional just statutory interpretation case. And like, yeah, it's in a context that is, that people have strong feelings about, but it really was not like a radically aggressive statutory interpretation argument. Like, it's a tough statutory interpretation issue, and plenty of courts could have come out that way. And then if you look at Jarkisi, like, the court didn't accept the most aggressive arguments that the Fifth Circuit accepted, and it just didn't address those. And by virtue of the way the court resolved the case and ruled on a particular issue, it was able to avoid some of the more aggressive things that the Fifth Circuit had said. So but I don't think that's like lost on the Fifth Circuit. I think the judges who are pushing the envelope, they know they're pushing the envelope. They view it a little bit as, we have some room. If we can find any way to make the argument, we might as well, and we might as well force the issue and force it up there. Speaking as both a conservative and somebody who does a lot of agency overreach cases, sometimes it does make me a little nervous because I just worry about, like, you get the wrong cases up there and all of a sudden you have some bad standing law, or there'll be one of the interesting cases this year that's a little bit under the radar out of the Fifth Circuit is the White Lion wages. It's an APA case that's just a case that was resolved under the arbitrary and capricious standard, and we'll talk a little bit more when we get into this term's big admin law cases about all of that. But like, that's a case that could be a sleeper that's like really important and good for agency overreach challenges, or it could end up being like, like, we get some bad law on a really important developing post-Chevron area. So I do think the court's being forced to take a lot of cases out of the Fifth Circuit. And some of them, the Fifth Circuit's coming out right. Some of them, I mean, I was part of getting them reversed in one of the cases, so I certainly don't think they're getting all of them right. But all of it is, they're clearly more aggressive and further to the right than anywhere close to a majority of the Supreme Court is right now.
Yeah, I think Mike and Erin have said most of what I think about the Fifth Circuit in this context. I'll just say 2 things. One concrete example of what Erin's saying about the Fifth Circuit's aggressiveness potentially making bad law is probably Rahimi is a great example of that, right? Like, there are a lot of other cases you could imagine coming up to the court. Erin's going to talk a little bit more in depth about Rahimi, but this is a case, it's a Second Amendment case with just about the most unsympathetic facts you can imagine for the kind of challenge that was being mounted. The guy in question had a domestic violence restraining order against him. He was clearly truly very dangerous, someone you would not want to be armed. And the Biden administration rushes as fast as possible to take that case up to the court to resolve some questions about the statute. In another circuit, I think that case probably fails, and the Biden administration has fewer vehicles to pick to take up to the court.
It did fail in most of the circuits.
And coming right behind it is a challenge to a guy who's stripped of his right to possess firearms because of, is it food stamps fraud, the range case?
That's what it is.
Right, he commits fraud to get food stamps to feed his family, and therefore stripped of his right to bear arms, and therefore winds up facing this long criminal sentence when he's found possessing a firearm, right? You can imagine that that's the case that maybe some people would have wanted to see up at the Supreme Court on this question of the Second Amendment and when you can bar someone from possessing firearms. But the case that went up, thanks to the Fifth Circuit, was this Rahimi case. On the other hand, I think it is indisputable the Fifth Circuit's had a really important role in kind of widening the Overton window, right? It is the case that once a court rules on a theory, the window is a little bit more open, and what has become what is a kind of theory that feels fringe or that is purely academic takes on new life once the Fifth Circuit accepts it, whether or not the Supreme Court ultimately sides with them. I think that Jarkissi is a good example of this, right? The Supreme Court does rule on a narrower ground. It doesn't touch two of the kind of more extreme grounds that the Fifth Circuit articulates, but like those are still good law in the Fifth Circuit, right? I mean, there's still one circuit where those two theories carry the day, and I think that's pretty significant.
Yeah, just very briefly, I think that Overton window point is an important one, and it's not just the Fifth Circuit. I think it is also that in some of these cases, if you're picking up 1 or 2 or 3 votes from Supreme Court justices, that can perhaps embolden litigants or other lower court judges for similar theories in the future, or maybe even the same theory if the composition of the court changes.
Which is why, to the hypothetical question you posed earlier, like I don't think they're going to be we're chastened and we're done. I mean, it's an important role to them that they're playing in. It's a little bit like if you think about people always talk about Justice Scalia always talked about how he wasn't writing dissents for his colleagues, he was writing it for the next generation to see and hear those arguments and be inspired by them. And I think there is a bit of the Fifth Circuit thinking about it as these are important arguments and we should be helping air them. And just because we don't think there's a majority of the court up there doesn't necessarily mean we shouldn't decide cases the way we think is right. Some of that's going to create really good law because some of it is forcing some issues up there that the court might not otherwise deal with. But this is a good transition into our final kind of topic about, just before we get into some more specifics about some cases, we just wanted to touch a bit about where the court is on originalism, and I think Rahimi's kind of the most important case there. And I will say, to Easha's point, means I do a lot of Second Amendment work. We ask the court to hear a lot of cases, and our clients are not usually criminal defendants at all, let alone extremely unsympathetic criminal defendants. Now, I talked a lot with Mr. Rahimi's counsel during the process, and I mean, you're a public defender, you've got to make the arguments that you need to make for your client, and he did, and the Fifth Circuit accepted them, and you can't not make those arguments when you're defending somebody in a criminal case, and it's just a little bit, I'm not sure, I don't think Rahimi and his counsel really wanted that to be the case that was at the court either, but it just sort of ended up that way. And the question will be, how much does the Rahimi case mean? I'm sure you all recall, we have a few years back, 6 members of the court joining the Bruin decision, where the court definitively said, we're going to apply this kind of originalism, historical tradition, methodology in the Second Amendment context, with Justice Thomas writing the opinion and saying, we're not doing tiers of scrutiny, any interest balancing. We're going to look at the text and ask, is something kind of presumptively covered by the text of the Second Amendment? And if it is, then the whole question is about, is it consistent with historical tradition? We're going to look, are there historical analogs, similar laws that were out there? How are we going to, we're going to look at that to be our deciding factor of, are these laws today similar in how and why historical laws imposed restrictions on Second Amendment rights? And one of the biggest things that was sort of open after Bruin was this idea of, what level of generality do you do that analysis at? And I think that's really what Rahimi is mostly about. Because the kind of two views of the case, we ended up with the decision that was on the bottom line 8-1, with Justice Thomas, the author of Bruin, being the one dissenter. And Justice Thomas, consistent with some of the most aggressive language in Bruin, was basically like, I don't see a historical law that prohibited people who have a domestic, are subject to a domestic abuse restraint order, like saying they can't have a gun. And like, that's the end of it for me. We could have had these laws, they didn't exist. Nothing almost exactly like them existed, I'm done. And the majority did a higher level of generality and said, well, we think it's close enough that there were laws that imposed, special, you had to pay a bond to continue carrying a firearm if you had threatened to use it against somebody else, to commit violence with it. You could be punished for using firearms in certain ways, and that would disable you from carrying them. They said, that's all kind of close enough for us. And then you get probably one of the more interesting pieces of Rahimi is all of these separate writings. So, of course, you have the Bruen dissenters writing to say, we're so glad the court has abandoned Bruen, which is probably, a massive overstatement. But to be fair, they're in the majority, and they're pointing out, like, this, the author's in the dissent, and everybody else is here, and we're taking different approaches. But I think you can't lose sight of the concurrences. And we had concurrences in the case from Justice Gorsuch, Justice Kavanaugh, and Justice Barrett, all reaffirming a commitment to, no, we do think this is the right way to do it. We think an originalism approach, a historical tradition approach is the right way to do it, and then exploring what that means. And so you have this really interesting dialogue at the court going on right now. I mean, I would say, I think there's basically 4 justices who are like genuinely committed to the concept of originalism and historical tradition, those 3 plus Justice Thomas. You've got 2 other conservatives that I think are kind of like, originalism. Like, we're with you as long as it kind of goes where we want. We're not quite as doctrinal about it and militant as some of you may be. And then you have an interesting dialogue, on the other side of the court really starting to push back and say this whole idea is wrong and we shouldn't be focusing on it that way at all. But I think there's a lot to be watching among the 4 because they're kind of controlling this and they have different views. They have different thoughts about the right way to approach it. We saw this really interesting dialogue happening about the concept of tradition. Is tradition something that matters independent of how historical it is and how closely it's tied to the founding? And basically, Justice Barrett said, like, no, it's kind of got to be historical tradition and it's all got to map onto that. And Justice Kavanaugh kind of saying, no, tradition may have this important independent role to play in all of it. You have this debate that's still going on, just as a technical matter about like what is the relevant historical period for a given constitutional amendment. For the Second Amendment, is it when the Second Amendment was ratified or is it when the 14th Amendment was ratified, at least if you're dealing with the state? So I think you still have very much justices who want to, they are fully still on board with the idea that, yeah, we get it, this isn't perfect, but we still think it's the best way out there. But they are very much working through, Bruen's kind of the first time you really see the court try to like actionalize this concept and say, this isn't just in theory how we're going to do this. And certainly Heller was an originalist decision, but trying to lay out like, what does it mean to decide cases in originalism fashion? And as someone who litigates a lot of these cases in the lower court, like that is a work in progress. The lower courts have radically different views of what it means to do that. And it's been really just an interesting, fascinating dialogue to watch that going on among the justices and among the lower courts, trying to figure out for those, some are just like, this is stupid and we're not historians. And that's frustrating because the court's kind of saying this is what you're supposed to do. But it's, with the ones who are really struggling to say, like, we get it, you're telling us to do this, but how exactly do we do this? We got some really interesting writings, not even just in Rahimi and a few other cases this year that give a little more insight into how some members of the court are thinking about it.
Oh, so I agree with a lot of what Erin just said, and we'll try not to just repeat it. I will say I think that this level of generality issue is a really important one, and happy that Erin and I agree that the opinion stands for a high level of generality.
Those words did not come out of my mouth, ever.
But I do think it's interesting.
We do have pending cases against each other on these issues.
I think that this has been described, and maybe appropriately so, as a relatively narrow opinion. The chief was writing to try and keep 8 justices on. It's pretty remarkable to have 8 justices on a Second Amendment opinion. And so in some respects, it is relatively narrow. I do think it's significant for a lot of the reasons that Erin indicated, because of some of the points that are made succinctly, but still made in the majority about this level of generality issue. We've had in the wake of Bruin some lower courts that have adopted a sort of hyper-granular understanding of the historical inquiry and really sort of said you need a spot-on historical precursor to justify a modern regulation. And you've got 8 justices of the Supreme Court that join an opinion that says some lower courts have misunderstood our framework and take the Fifth Circuit and the dissent to task for taking that approach. Now, that still leaves a lot to be decided about where exactly is the right general level of generality, and I'm sure Erin and I will be debating that until we retire. But I think that that's an important message that I hope will not be missed by litigants and lower courts. And the second point, kind of building off of that and building off of where Easha started today's discussion, is I think Justice Barrett's concurrence here and in conjunction with the concurrence in Vidal is really important, because she expands on this point about the level of generality and talks at some length about why it's actually quite problematic if the level of generality is too specific, because then what you're doing is effectively limiting the policy options of modern legislatures to choices that were made by legislatures in the late 1700s or early 1800s, depending on where you land on the relevant historic period. And at the same time, you are sort of assuming that those historic legislatures legislated to the full extent of their power, which is not always a safe assumption. So to have that coming from Justice Barrett, I think, is going to be influential in future Second Amendment litigation. And it sort of builds on things that she said in the concurrence in Vidal about really this is about identifying legal principles, enduring legal principles that can be applied to specific facts and specific laws, and that the search for tradition shouldn't be an end in and of itself. And as Erin indicated, there's a lot of debate on that on the current court, and I expect that debate will continue to play out in the years ahead.
So I have maybe actually a genuine question for you, Erin, about Rahimi, which is, so I may be like the only person in the world who's skeptical of both the Bruin and Rahimi majorities, but on Rahimi, so I get why we look to a historical tradition with a similar burden, right? Like, is there a 20-year sentence attached to something or not? That seems like a pretty significant difference in how you're regulating it. I guess I'm a little bit skeptical about the search for a law with a comparable purpose for all the reasons that we talk about in every other setting, right? Like, it's hard to figure out what the purpose of a law is. And so to the extent Rahimi lays out this kind of 2-part test, right? Look for a historical, a law that imposes a comparable burden on a historical right. That tracks to me. I happen to think Justice Thomas is right that none of the laws you're pointing to in the majority are anywhere near the 20-year prison sentence at issue. But the looking for a law with a comparable purpose strikes me as a little bit of a fool's errand, or at least it's what we've said in other contexts. And so I'm curious your take on that piece of the puzzle.
Yeah, I actually think this is a really important piece that just hasn't kind of come out in the types of cases we've had yet, because where I think it comes most into play is in regulatory burdens that are less like a law that bans something and more putting obstacles to the exercise of the right. And so if you think about, like, in Bruin, there was a footnote the court dropped where they kind of say, look, like, we're probably fine generally with like background check licensing regimes, but if you have a licensing regime that's just creating a ton of delay, like for not really any sake and keeping people from exercising the right, and it's not tied to getting the license, like, then you start to worry that that's not really what's going on, and what really is going on is just trying to keep people from exercising the constitutional right. And I think that's what the court's getting at. And I'll use an example from a case that California won pre-Bruin, but I think is an important issue post-Bruin that to me teases this up nicely. So, like, there are laws that have existed through time where you have a waiting period while a background check is conducted. So you can't get the gun till the background check's done. And then there are laws like California that says even if you pass the background check, like, you just can't get it for 10 days still. Because we just are worried, like, that if you want a gun, you probably are up to no good and you should have 10 days to cool off and think hard before you exercise your rights. Those are two things that you could have the same regulatory impact, but one is imposed for, like, in furtherance of, well, we need the time to go do the check, and the other's imposed for like, no, we don't trust you to have a gun because we just think like people who want them are sort of fishy. Like, I think that's what the court's getting at when they're talking about the why, is sometimes we're going to have to look and say, even if things look like the burden is the same, if you're actually just imposing it for the sake of deterring constitutional exercise of constitutional rights, that's a concept we have throughout all of constitutional law, that it's like, that's what you get at when you're thinking about the First Amendment. Have you restricted the rights in service of something that's not about, that's incidental to the fact that it's burdening speech, or are you burdening speech for the sake of burdening speech? I think that's what they're trying to preserve the room for that, but we just haven't seen those types of cases get to the Supreme Court at this point, because most of the cases have been more like ban cases or things that really precluded the exercise of right at all.
Yeah, that makes a ton of sense to me. And I think the source of the confusion then is why you would tether that purpose to a historical inquiry, because you're right, in every other setting we have this kind of pretext inquiry. Are you just trying to burden the right for the sake of burdening the right?
Like, and I think historically the answer is just going to be like, no, we never had things where you burdened it for the sake of burdening it, so it's not really tethered. It's more just like sussing out bad intent. Like, I think that's a little bit more, it's a way to say, even if you, because it only matters if you assume that you did have a historical analog in terms of the burden. And so you're looking, like, it would only matter in a case where you're able to say, well, yeah, there was a law that imposed a similar type of burden, but it wasn't for this purpose. It was for something else entirely, and so we're not going to let the burden alone control the analysis. That's the only type of case I can imagine where the why issue actually ever impacts the outcome of the case. So if you posit it that way, like, that seems to kind of...
Right, it just opened this whole Pandora's box to let people argue, well, the why was not to prevent domestic violence, because domestic violence wasn't a concept of the founding. And I think your take is that's not the sort of why we're looking at. We're just looking at, were you trying to burden the Second Amendment right for the sake of burdening it, or any other reason is okay?
I mean, that may be higher than I'd be willing to put it, but like, I think that's what they're getting at. I think that's why there's a why there, is so you can suss out when you're doing something that's just inconsistent with the reasons things were being done historically.
All right. Okay, well, so my job now is to set the stage for a conversation about the Trump cases. So I'm going to talk a little bit about the kind of two big Trump cases from this past term, and then open it up to Mike and Erin to have a discussion. So let me start with the immunity case and do some pretty quick stage setting, because I think we're all pretty familiar with the broad strokes of this case. So special counsel Jack Smith, is prosecuting once and possibly future President Donald Trump for various conduct in connection with trying to overturn the results of the 2020 election. 4 big buckets of stuff he's targeting, trying to start various sham Department of Justice investigations in order to cast doubt on the results of various states' elections, conversations with the vice president to try to alter the results of the election, conversations with people outside the executive branch, so state officials, private parties, to try to organize these kind of fraudulent slates of electors, and public communications levying these sorts of false election fraud claims. And so the majority says in this case, presidential acts are divided into 3 categories, and whether or not you can be prosecuted depends on which bucket you're in. So bucket 1 is the core stuff. That is the stuff within the, quote, conclusive and preclusive constitutional authority of the president. That's stuff like pardon power, veto power, recognizing a foreign government. As to this stuff, absolute immunity, right? No prosecution. Of the 4 buckets I talked about, this is the first bucket. The court says the sham DOJ investigations, that falls within the kind of exclusive authority over deciding how to exercise the prosecutorial power of the federal government. Bucket 2 is the stuff that is official but not core. And for this category, the president has at least presumptive immunity. So the court doesn't tell us, maybe absolute immunity, but at the very least, you've got to overcome a presumption of immunity. Trump's conversations with Mike Pence are in this category, so that's bucket 2. We're not deciding yet about the other stuff. We're going to remand. And the only test here for what counts as, what counts as official and not core is an official act cannot be, quote, manifestly and palpably beyond the authority of the president. Whatever that means. Bucket 3 is unofficial stuff, and as to that, no immunity. And critically, in determining whether something is in category 2, which is the official non-core, versus category 3, the unofficial, you cannot look at the motives of the president. So, and then on top of all of that, the president gets this one additional degree of protection, which is that if there's immunity for something, you not only can't be prosecuted for it, a prosecutor can't use that conduct as evidence of something else. We saw a week or two ago, Jack Smith, the special prosecutor, kind of put forward his position in response, and I think next week we'll see the Trump team weighing in on that. He basically says, okay, except the DOJ investigation stuff goes, conversations with the vice president, I think it can overcome the presumption of immunity, because talking to the vice president to try to force him to do something corrupt should not get immunity. And then you see him sort of really finely parsing the evidence to figure out what else goes in which bucket. So there's for instance, one conversation between Donald Trump and Mike Pence where he says, I should be able to let in the part Donald Trump says, where he says, good to have lots of our supporters in town on January 6th, right? He said, that's unofficial, that's candidate stuff. But I agree that I have to exclude Pence's response because he responds by saying something about certifying the election. So that's the level at which, the sort of level of granularity at which we're gonna have to sort of parse the evidence in this case. There's a bunch of separate writings in this that I'm sure we'll talk about. To me, among the more interesting pairing are Justice Barrett and Justice Sotomayor. Justice Sotomayor dissents, Justice Barrett concurs. I actually happen to think their bottom lines are the same. They just have different tacks with dealing with the kind of majority. When you see this pattern all over the Supreme Court, the question of how to deal with the majority opinion you think goes too far, one tack is the Justice Sotomayor tack, which is sort of sound the alarm, tell people just how broad this is. The other tack is the Justice Barrett tack, which is to be like, you know what, actually, I don't think they're doing all that. They're really saying this very narrow thing, and I understand them to be saying this very narrow thing. And then just quickly, the other case I want to put on the table for Mike and Erin to talk about is Trump versus Anderson, which is about Section 3 of the 14th Amendment. So remember, that's the provision that disqualifies someone from holding office if they previously held office and then engaged in insurrection or rebellion. Colorado Supreme Court says Donald Trump falls squarely within this. We're keeping off the ballot. Supreme Court says states can't be the ones to decide whether or not a federal official is disqualified, and seems to say, we can sort of talk about the scope of this, but seems to say only Congress by passing legislation gets to make that determination. So I think that's all I'm supposed to do by way of setup, and now I'm curious to hear your thoughts about either or both of these cases and what they tell us about the court.
Sure, so I'll start. So, I thought a lot of the reaction to the Trump immunity case was pretty overblown. I think for the most part, if you look at it like, if anything, it's a little frustrating how little it actually decided. So if you kind of look at the broader litigation there, I mean, essentially, it started out as this case where you had two pretty extreme positions. The DC Circuit had accepted a pretty extreme position that there was essentially no immunity, and the Trump camp was kind of arguing that there was essentially complete immunity. And by the time it got to the court, they'd kind of both, I think, realized they had to moderate those positions. And while they hung on to them like a little bit, more or less everyone agreed the unofficial acts are out. And like, while the government had a different way of getting there, it kind of had its own way of saying the really core official stuff is probably not going to, the category 1 stuff's probably not going to be covered for other reasons. And so the whole fight was just about like, what do you do with the stuff in the middle that's official acts, but not in that classic Justice Jackson Youngstown concurrence world of like exclusively presidential, but rather, the twilight in the middle or whatever the phrase is. And essentially the court, just like Justice Jackson's concurrence, which I've always thought it's interesting that people find it this wonderful thing, because I read it and I'm like, okay, this is like gives me a framework, but doesn't actually tell me much. And you look at the opinion, and the opinion just kind of creates a framework. And it's like, you got the stuff at this end, and that's immune, and this end, and that's not immune, and then there's stuff in the middle, and like that might be immune, but we're not sure. And then they don't actually really decide what is and isn't immune in this particular indictment for a lot of the issues that were in there. I think it's all like very much consistent with kind of writing this opinion for the ages concept, and we want to lay out a framework and a conceptual way to think about all of this. But it does, to me, make it a little like I think the sounding the alarm is all like a little hyperbolic when you have an opinion that like goes out of its way to not take a position on a lot of the questions about exactly what is and isn't in the bucket. Personally, I thought that the thing that I found interesting about across both the cases that gave me a little pause and I had to think a little bit about, but kind of ultimately think I came to conclusions about it is both of these, I mean, one is unambiguously an opinion written by the Chief Justice. According to various reports, they're both opinions written by the Chief Justice, but Trump v. Anderson was written as a per curiam opinion. But the Chief Justice is very famously has kind of the line, if it's not necessary to decide, then it's necessary not to decide more in a case. Yet in both of the cases, the court went further than it needed to go. It went further in Anderson on the congressional issue. It went further in immunity on the use of official acts in an indictment and said, even if you're not charging kind of for official conduct, the official conduct can't even be used in service of seeking a conviction on non-immune conduct. And at first, that gave me a little like pause that you've kind of got the Chief Justice there in opinions where it's pretty clear as sort of a jurisprudential matter, you don't need to do more. I think on reflection, that this is a product of, there's certainly like this Trump fatigue at the court. They don't want to be doing all these cases at all. I think sometimes there's this perception that they're going out and grabbing them. Like clearly they all don't want to have a Trump docket. And I think that if you think about that institutionalism and that concept of like, we don't want to be doing this all the time, I think that's probably what led the majority and the Chief Justice to be in the majority that went a little further with the idea of, look, we don't want like Anderson coming back to us in a couple months with a debate now about Congress and like with the debate about what else can happen. And we don't really want like just this, to like remand this indictment of the DC Circuit and have them just kind of pop it right back up to us. And if we go a little further in these cases, we're going to actually deal with like not quite having to keep having these cases come right back to us. As you say, even though, obviously there is a new indictment, but it's a lot, they had to do a new indictment because of the way the court resolved the case. There was basically no question you didn't have to supersede the indictment once they issue the ruling that talks about how you can't even use the allegations that are in it. So, to me, some of that really is a product. I don't think it's driven by like, oh, we want to give like Trump big wins, because I think there's several justices in this majority in these cases who are no huge fans of former President Trump, but I think it's more thinking about it from that institutionalist perspective of we don't want to have a Trump docket. And is there a way we can kind of decide these cases at a higher level in a little bigger way that maybe keeps us from having to kind of keep coming back to this stuff? And particularly in Anderson, may keep us from, you could still have like the very thing that was driving that case and led to everybody agreeing on the bottom line is the constitutional crisis you would have if it's unresolved all the way up until the day you're going to have a president take office, whether there's some mechanism for kind of invoking these arguments and creating issues all the way up until the vote. And I think they were just like, yeah, we don't want to deal with that. We're going to lay that to rest now. But.
So for my part, on the immunity case, I don't think it's overblown. I think it dramatically alters the legal checks available in response to criminal conduct by the most powerful person in the world. And so I expect that it will be a very consequential opinion. And I think some of the pushback or criticism of the opinion is not so much that it's a framework or a three-part framework. It's sort of the breadth and haziness with which some of these buckets are defined. You heard the manifestly and palpably, I don't know what that means, but it sounds really broad. And if you're in that second bucket, we don't even know whether you get absolute immunity or presumptive immunity, but then the court says something about how you might rebut the presumption, and that seems fairly demanding too. So, those are my 2 cents. I guess 2 observations about the majority opinion. first, returning to a subject we talked about a little while ago, whatever you think about this opinion, like it or hate it, it ain't an originalist opinion. You know, what you see is 6 justices of the Supreme Court acting in good faith and looking to some available precedent that's not very on point, and their own intuitions and predictive judgments about the future to come up with a framework that they think is in the best interests of the United States going forward. And I'm not here to criticize that, but I think that the point raised by Justice Sotomayor's dissent is a fair one of, you know, it's not a great look if it appears that the court is sort of looking to history when it's most convenient. I don't think that that's uniformly a fair criticism. I think the CFPB case is a great counterexample. But here, I think the court really did not seriously engage with the history, and I think that if it had, it would probably end up in a different place in various aspects of this framework. The second point is, I think, you know, the debate between, sorry, I'm gonna exercise my prerogative to go a little longer here. I think the debate between the majority and the dissent here really does boil down in substantial part to a kind of debate over competing policy concerns, consequentialist concerns, and the majority is clearly animated by a concern that if you let this prosecution go forward in the original form, that you can't unring that bell, and then there's going to be successive prosecutions by future presidents of the prior president, and that will be destabilizing to our government. And I think that's a very legitimate point. I think that has to be part of the consideration here. The dissent is motivated by a legitimate concern that if you hand this framework to future presidents, perhaps the next president, it will allow folks to engage in unlawful conduct that could pose an existential threat to our republic. And you know what, I think one of the things that's most striking to me about the majority is just how dismissive it is of that concern. I mean, it sort of says, you know, it mocks the tone of doom in the dissent and says this is fear-mongering and extreme hypotheticals. And I confess to being a little bit puzzled about that. I mean, I think if one has been sort of paying attention for the last 8 years or the last, you know, 8 days to various public statements made by major party presidential candidates, they don't seem too extreme, or at least it seems worthy of consideration. And maybe you could balance these competing policy concerns and end up, you know, essentially where the majority did. But I was a little perplexed by the dismissive tone.
Well,
Do we have to move on to admin law, or can we keep talking about Trump? What's
I won't insist on a rebuttal. So let's move on. Let's move on to admin law. So when the court wasn't dealing with Trump this year, kind of probably the biggest thing that was going on this term was there's a huge term for administrative law, and probably, I mean, one of the most important terms ever in terms of just the importance of the cases. We'll talk about how consequential they are in real world. Who knows? And certainly the headline here was the Loper-Bright case that overruled the Chevron doctrine. So I'm sure people are generally familiar, but just, you know, brief refresher, because I do think there's like it's important to recall what exactly Chevron is, because a lot of things just get lumped under the concept of agency deference. But Chevron is the doctrine that says if a statute is unambiguous, then a statute that deals with the powers of an administrative agency, then the court would defer to the agency's reading of the statute if that reading is reasonable. And that's a doctrine that had been on the books for roughly 40 years, but if you've been paying attention to the court for the past, you know, at least decade, several justices were not big fans of it. It's been a theme on this court for many years, even before some of the newest members. A lot of agency pushback, on agency overreach, a lot of concerns being raised about the Chevron doctrine and where it has gotten. And it's a really interesting kind of debate that's been going on, because a lot of the defense originally with the Chevron doctrine was actually kind of an idea of, it was a little bit rooted in the concept of we should have democratically accountable decision makers, and some of the defense was the idea of, look, if it gets down to a point where we're not sure what the answer is, as between an administrative agency that's at least sort of like part of a politically accountable branch versus the judiciary, which is not, we'll have the administrative agency decide it. Over time, I think for a lot of justices, they've come to see that very differently in terms of, whoa, this kind of expanded exponentially in terms of how much deference these agencies are getting, to the point that they seem to be making law now, and they're not really that politically accountable, given that they are, kind of quote unquote independent, operating a little bit outside of the purview of the executive branch, and a little, and clearly in the context of ambiguity, outside of anything Congress has clearly said they should do. And the court started to instead look at this as, we've empowered sort of this, like, fourth estate monster that is doing a lot of things that it's not clear that they were ever actually given congressional permission to do. And it's our job as the courts to be looking at the law and asking whether they have that power, and standing there as sort of a guardian of individual rights and liberties against that kind of agency overreach. And you've just seen that theme develop among members of this court for quite some time now. And as part of that, we saw many years where Chevron, the court just never even mentioned Chevron deference, let alone relied on it. The last time they had a case where they had relied on it was when Justice Scalia, who was actually a champion of it, was still on the court. For years, it's just not been part of the court's jurisprudence. But they finally did take up a case last year about whether to overrule the doctrine. And as I'm sure you all know, in a 6-3 decision, they decided yes to completely overrule Chevron, get rid of Chevron deference, and, as the majority put it, return the ultimate question of how to interpret statutes to the judiciary. And a lot of what the court said is, look, in any other context, when we don't have an administrative agency at hand and we have to interpret a statute, we just do it. It may be hard, it may be ambiguous, but we have all these tools. We have ways we look at the text, we look at the whole text, we have canons of interpretation, we have all these things, and we don't just get to throw up our hands if there's not an agency and say, well, we don't know what it meant at the end. I mean, you have vagueness doctrine as a backstop, but generally the court's job is to figure out the best reading it can of a statute. And they said, this has turned things upside down for 40 years to have essentially given that task over to part of a different branch. That's what we're supposed to be doing, and that's what we're going to start doing again. I think one of the interesting things about the case is that you basically have the debate come full circle, because while you've had all of this dialogue for quite some time among the more conservative justices who were in the majority here, what you have from the 3 justices in dissent is back to that idea of, no, you're actually taking kind of power away from agencies that have more democratic accountability than this court, and you're aggrandizing the court at the expense of the agencies. And so we sort of still have the same basic debate that was kind of going on all along, with a little bit of role reversal in who's approaching it from which perspective. And we really saw that theme across multiple cases this year, this notion of, of pushback on the idea that while the conservatives think of this whole admin law project as being guardians of individual liberty, the dissenting liberal justices saying, no, this is really about, accruing power to the court. And I think we're going to see that continue in cases over coming years that deal with these issues. But just to set the stage on one other piece of this for purposes of discussion, so one of the huge questions is, how much impact does this case have? And we can talk about that in terms of just the overruling of Chevron in and of itself. But another important piece of the puzzle this term that could impact all of this was a case that was a little bit more of a sleeper called Corner Post, which is a case that dealt with the question of when you can challenge an agency rule or regulation. So the general statute of limitations is 6 years from when your claim accrued. And the basic question, most of the lower courts had always said, and in most cases this is an easy answer, your claim accrues when the rule or regulation was enacted, was promulgated, was adopted. So you've got 6 years from then. But the question in Corner Post was, well, what if the plaintiff didn't exist then, and it wasn't personally impacted by the rule or regulation for many, many years to come, because it this was like a new company that was kind of created, I think, to challenge the regulation, but nevertheless hadn't existed, could never have sued in that time period. And the question was, is your claim still barred? Did it still accrue when the rule or regulation was enacted, or did it not accrue till you personally were injured? And the court, in another 6-3 decision, said, no, it doesn't accrue until you personally are injured, which creates the possibility to now, go back in cases involving challenging rules and regulations that have been on the books longer than that 6-year statute of limitations, if you can find a plaintiff who's in that position of being able to say, I wasn't injured then, I was only injured recently, and I can reopen all this debate, and then you get a chance to go relitigate some of these same things that might have been resolved at a time when Chevron was applied and might have been resolved in a court that actually used Chevron deference to resolve the case in the agency's favor, and get a chance to, maybe that's a circuit court decision in one circuit, and now you get to go to another circuit, challenge the same rule or regulation with Chevron no longer on the books. So I think when you put these two pieces together, you kind of have to think about the interaction of the two cases when thinking about what exactly, what all impact are we going to see from these important changes this year on the court's docket.
So some quick thoughts about Loper Bright. I will refer you to Justice Kagan's dissent for criticisms of the majority opinion, but that is the law of the land now. And I think that there are some interesting questions that are left open that we're going to see litigated, and I wouldn't be surprised if lower court judges come to different opinions on them. So one thing that's interesting is the court says we're done with Chevron deference, but of course this is about effectuating the intent and will of Congress, and so Congress can, in some circumstances, appropriately delegate to agencies to sort of fill in the meaning of broad statutory terms based on the facts. And I don't know that there's a lot of clarity on exactly where that's appropriate, what Congress has to do to accomplish that delegation, and then how we're going to review those types of agency actions. So I expect a lot of litigation in that area. Second, there's this question of, well, what deference, if any, remains, and does Skidmore deference remain? I remember sitting in this exact room as a 2L in admin law trying to understand what the heck Skidmore deference is. I'm not sure that I've totally wrapped my head around it, but the opinion seems to suggest that that's potentially still in play. And I wouldn't be shocked if you see different district court judges disagreeing about how much of a thumb on the scale you might be able to give under Skidmore. It does seem that, from the majority opinion here, one area where agencies might have the strongest argument is if there is a contemporaneous, long-standing interpretation that they adopted shortly after the statute was enacted, and they've stuck with it even as administrations have changed. So that's another area where we'll see a lot of litigation. And then potentially down the road, this was a statutory holding. There's sort of some constitutional music in the background. There were constitutional arguments in the case. Some justices made clear that they think Chevron is impermissible as a constitutional matter, but the opinion leaves open the possibility that a future Congress could codify Chevron, and then presumably we'll be right back up, and Erin and her colleagues will be making the same constitutional arguments. So
I forgot to say, we did litigate the case.
So those are my thoughts, and I'll be interested to watch this in the coming years.
In the interest of time and getting toward the Q&A, maybe I'll skip thoughts and give them during the Q&A if someone brings it up. And Mike, do you want to talk a little bit about the other big theme of this last term?
Sure. So the last theme we wanted to touch on is, I guess you could say, deciding not to decide. A number of big cases this term where the court did not reach the merits for one reason or another. And I'm going to focus on two cases out of the Fifth Circuit where the court rejected somewhat aggressive theory of standing. So the first is Alliance for Hippocratic Medicine. The plaintiffs were challenging two FDA actions that made it easier to prescribe and obtain mifepristone, a drug for abortions. And because those actions didn't directly regulate the plaintiffs, require them to do or not do anything, they had to come up with a theory of standing. And the theory was, basically the greater availability of mifepristone will lead to more complications from mifepristone, more patients coming to emergency rooms needing emergency abortions, and the individual plaintiff doctors and members of the plaintiff organizations would then need to participate against their strongly held beliefs in those procedures. The second case is Murphy against Missouri. I'm not online much, but apparently there's misinformation going on in social media about subjects such as COVID and elections. And the Biden administration and some senior officials had a lot of outreach, particularly in 2021, to various prominent social media platforms. And the plaintiffs included folks who had their content demoted or restricted or banned. And they were arguing that they were injured because the defendant federal officials effectively coerced the social media platforms to restrict their content. So the plaintiffs were able to obtain fairly sweeping relief in district courts in the Fifth Circuit, and the Fifth Circuit panels in both cases substantially affirmed. And the Supreme Court reverses, and the opinions in these cases sort of read like the model answer on a 1L Civ Pro exam on standing. I mean, there's a lot of discussion of sort of bedrock principles of standing and then extensive application of those principles to the substantial records in these cases. And in the Alliance case, Justice Kavanaugh writes for a unanimous court and says there's a causation problem here because the plaintiffs haven't really established that they or other doctors have actually had to, in this situation, participate in an emergency abortion procedure. And in fact, the US Solicitor General had conceded that federal conscience laws would protect them from having to participate. In Murphy, Justice Barrett writes for a 6-justice majority and says, well, if we look going backwards, almost all these plaintiffs haven't really been able to match up the injury they suffered, the restriction on their posts, to a specific communication from a federal official to their social media company. And there's certainly not enough to predict that there's a substantial risk of that happening going forward, especially since the Biden administration has kind of backed off of this campaign. So I don't think that there's a ton of doctrinal news here, with the exception, as Erin mentioned, in the Alliance case. I think the court does kind of rein in the organizational standing doctrine and narrows it substantially. So this is another example of a potential downside of bringing audacious theories of standing up to the Supreme Court. I do think there are some practice pointers here. One being, you can't assume that just because you think a justice might be sympathetic to your cause that they are going to bend Article 3 to find that there's a case or controversy and reach the merits of your claims. And 2 being, especially if you're an unregulated party, you really need to develop a concrete record. I mean, we saw Justice Kavanaugh and Justice Barrett in particular poring over these massive records. I think Justice Barrett spent 20 pages talking about specific facts in the record. And that's, they're not going to, settle for sort of hand-wavy theories of causal relationships. So I guess the last comment is, I think some have described this as these as sort of punt cases. I don't view these cases in that way. I think that the court kind of had to grant these cases because of the breadth of the merits rulings and the relief granted. And once they granted them, if they believed what they'd said about standing, they sort of had to reverse on standing grounds. There are some other cases, including the other big abortion case, Moyle, that we might hear about that might fairly be described as more of a punt.
Yes, maybe I'll just add Moyle to the table on this front. So this is frankly kind of a puzzling one to me. So this is the case where Idaho passes a 6-week abortion ban with an exception only to save the life of the mother. Federal government says, well, that conflicts with EMTALA, which is a federal statute saying if you get funding from the federal government through Medicare or Medicaid, you have to provide necessary stabilizing treatment in an emergency. And the federal government says, look, there's a delta between necessary to save the life of the mother and what we require as a condition of federal law. Federal law trumps state law, therefore this law is preempted. And the Supreme Court grants cert basically before the Ninth Circuit has the chance to resolve the case back in January. But then fast forward a few months, and the Supreme Court issues what's called a dig. So it stands for dismissal as improvidently granted. Basically, I know we granted cert, but we take it back. We don't want to deal with this case. Justice Barrett sort of tries to provide an explanation. She sort of says, well, both parties' positions have kind of shifted. What's a little weird about this is at the cert stage, right? One of the reasons the U.S. gave for not granting cert is our positions haven't been clarified through proceedings below. You should wait. I've seen this theory that the Supreme Court didn't want to decide a big abortion case in an election year. I guess, but back in January, they also knew this was going to be an election year, like when they granted cert. So I just don't know what happened behind the scenes here. I don't know whether there's some group wasn't going to be able to get to 5 and sort of put together this coalition to dismiss the case. I don't know what to read into the dismissal. So one interesting data point is a few weeks ago, the federal government came to the court and basically said, look, there's a similar case in Texas. Texas also has an abortion ban, also has an exception that's arguably narrower than the federal law. So can you do what's called a GVR, which means grant, vacate, and remand, the lower court opinion. So grant the lower court opinion, vacate it, and send it back down. So don't say anything, just say, look at what we said in Moyle and now reconsider in light of that. And the Supreme Court declined to do that, which on the one hand is maybe unsurprising, right? Because I think in theory, the dig in Moyle means it should have no precedential value. On the other hand, feels like something of a signal, like don't come to us and think that we are, that the dig in Moyle meant that we actually believe that EMTALA has any force to preempt these statutes. So I don't totally know what to do with this opinion, but it's certainly, I think that is fairly described as a punt.
I think that's right. I mean, I do think one important thing that through line across both of the abortion cases is the piece of the positions that probably changed the most was the position in both cases the federal government was taking about the scope of conscience protections for doctors and hospitals, for people who have a religious or conscious objection to participating in abortion. And I think rightly so, once it got to the Supreme Court and the Solicitor General's having to deal with these cases, was like, no, like, don't worry. There are conscience protections. They are clear. They are broad. We're not going to do that. And that was not quite the way the case had been litigated before. But once those concessions are made, it really changes some dynamics in both of the cases. Obviously, Hippocratic medicine has its own standing issues and all that, but that played into those too, because part of the argument about why there wasn't standing was you'll never have to worry about participating in any of this because there's these robust protections. So some of it, I think, is a product of your positions do change when you get to the court and you are arguing before. Everybody's positions are going to change a little bit. So one interesting thing that I will want to watch for in light of Moyle is I think that the reason the court granted that case, I found it a bit of a funny grant to begin with. It's a grant before cert. The court doesn't do that very often. And I think the best explanation for why they did it is all of this kind of bad press and attention the court's gotten for years about the shadow docket and how they do these cases that get resolved on emergency dockets and they don't, all that's kind of not fully aired and briefed and argued. And so they've tried to respond to that by saying, okay, we'll take these cases out of the shadow. We'll put them on our docket. We'll hear full, we'll have, it may be expedited, but we'll have full briefing and we'll have argument. And then you can't accuse us of, doing all this in the shadow. And I think this case, to my mind, was a reminder of just because everyone's criticizing us doesn't mean we were wrong. There's reasons we don't reach out and take cases before they've been resolved by any circuit in the country, let alone the one we're taking it out of. Positions do crystallize, facts, you get more facts, your positions change a little bit, they crystallize, all of those things that the court usually wants to happen, they require some process. And so I will be interested to see if some of this has any impact on how they think about that practice which is a pretty new practice, these taking the cases out, and if it may make them a little bit more cautious next time about, has this experience of, maybe it makes people stop complaining as much, but is it actually right for the court and our process and the way we do things? Or are we better off just taking the hit for, every once in a while we got to resolve stuff on the shadow docket and not say that much about it, and people may not like it, but at least maybe it's better than taking a case that isn't quite ready for this court to be dealing with yet. So I don't know how that'll shake out, but I thought it was kind of an interesting backdrop to the Moyle case in particular. I think we probably should start some Q&A if we wanted to hear from you guys instead of just hearing from us. So
We're going to start with 3 students, so if Jonathan, Perry, and David could join me down here, I'd appreciate it. Thanks, guys. Jonathan will go first, although unfortunately he might be the farthest away.
Yeah, thanks very much. You began today by talking about the court's use of history and tradition. I'm curious what animates the court when it shies from that methodology altogether. You noted today that the presidency has been one such context. You have Anderson, where the court seems to be motivated by sort of letting the people decide. You have Trump versus United States, where the court is worried about impeding a vigorous executive. You have earlier cases like Selah Law, where the court, in considering the extent of the president's removal powers, is looking at functional factors like the budgetary independence of an agency. And so I'm curious, first of all, what you think motivates those decisions. Second, why you think the presidency has been special in that respect. And third, if there are other contexts where you see the court shying from a full-fledged use of history and tradition.
So I'm going to give a very, very pragmatic answer on this. I think a lot of it's driven by who is writing an opinion, and some of that is driven by who gets to assign opinions. And in this current court, the justice who gets to assign opinions likes opinions about the presidency and isn't naturally the justice who writes the most originalist opinions. And if you're not writing, like, you may be, it's just, if you think about the take, like if Bruin had been written by Chief Justice Roberts instead of Justice Thomas, it would look very different. If Chief Justice Roberts had assigned Trump immunity to Justice Thomas, it would have looked very different. And so I think that's why, to me, one of the important drivers in all of this is recognizing, not to be unfair to a couple of them, but I really think there's only 4 of them who, at most, who think about it as, first and foremost, I'm going to approach cases as, through that framework. I think the chief in particular really is more his natural instinct is to start with precedent. And so a huge part of it, to me, is just driven by who's got the control of who's writing the opinion, and they get the best say about how the opinion is going to end up looking.
Yeah, I mean, the only thing I'll just add to that is I do think that's why people have sounded the alarm about this opinion, right? Because, I mean, the dissent is the one that sort of says, there's immunity other places in the Constitution, and state constitutions at the time had executive immunity and all the kind of founding era stuff. The majority, it's not. I mean, it's a little bit of precedent. It's a lot of a penumbra from the take care clause and this vision of an energetic executive. And so when people sound the alarm about this opinion, it's partly what Mike said, that this sort of middle category, everything might be in it, and you might not be able to overcome the presumption of immunity. It's partly the breadth of the core stuff. But I think it's partly the sense of well, if you're going off penumbras from the take care clause, who knows where this will end up?
Which is kind of funny to think we've come full circle on that. But
Yeah, and I would just say briefly, I agree with what both of my co-panelists said. I think another example of the sort of who gets assigned the opinion is the Vidal case that Easha was talking about earlier. I mean, I think that was assigned to Justice Thomas, and he wrote a very sort of history and tradition approach. I'm not sure it would have been written that way if it had been assigned to most of the other justices. And when you see Justice Barrett concurring, I think there's sort of a underlying consideration of, well, it's the First Amendment. There's already all this doctrine and all these principles. Shouldn't we be borrowing from that and analogizing to that? And so that might be another thing that drives individual justices in thinking, are we working in a doctrinal space where there's already a lot of developed precedent, or is it more like an issue of first impression, the appropriations clause, where there is more of an inclination to turn to history?
Hi, thanks very much for taking the time to be with us. Great talk. I have a question. We actually both have questions about Skrmetti. Mine is, why do you think the court granted the Skrmetti case brought by the United States rather than by the parents and the child? Especially when we're in a pretty tight election and the president and the administration might change and the United States might correspondingly change its position. Do you think it might have had to do with sort of the difference between the equal protection case that could be made versus a substantive due process case that could be made? And that way you sort of avoid the question of, parents' ability to make a decision about their child's welfare that the court, given Dobbs, might not like.
Thank you all for being here. So following up on that, we were also interested in whether or not we can potentially anticipate Chief Justice Roberts and Justice Gorsuch ruling similarly to how they did in Bostock. And then kind of tacking onto the flag for Dobbs, obviously Dobbs is raised in the briefs, and so we were wondering if you guys could talk a little bit more about the implication that Dobbs might have in this case, as well as future access to medical care, like access to IVF and further limits on abortion.
Okay. Well, I am litigating adjacent to this issue at least. So, and just so everybody knows, the case we're talking about, Scrimeti, is a case dealing with one of the states that has banned gender-affirming care. I'll loosely say it's a little different among each state exactly what that covers, but for minors. And the court did something pretty unusual procedurally. The way cases work when they come to the court is anybody who's a party to the decision below is automatically a party to the Supreme Court proceedings. But you might have, two plaintiffs and they decide to each write their own cert petition, and you're allowed to do that. And in this case, it was brought by the ACLU and private parties, but the United States had intervened on their side. And so you had cert petitions filed by both the United States and the plaintiffs who had brought the case. And the Supreme Court only granted the cert petition that was brought by the United States, and it's just holding. It just sits there. The petition brought by the actual plaintiffs in the case, which is particularly odd because they're still parties to the case, so they can still file a brief. They're just technically styled as a respondent, but they're still there, and they can still argue in the case and all this. So it's not like traditionally when you have two cases and the court only grants one. They're actually all just the same case. I find it very unusual, and the reasons you point out, it creates this weird dynamic where technically right now the United States has complete control over the case. The other case, the respondents / petitioners petition is just being held. So in theory, if the United States, if the administration changed and they dropped the case, the court could still grant the other petition. But it's just a little odd, and I don't think they didn't need to do it to narrow the scope of the case because the court can always decide what questions to grant on it. It can just say, we're only interested in hearing equal protection arguments. So I frankly haven't come up with the best explanation myself of why they did it. I find it odd, and the only practical impact it seems to have is letting the United States control the case. And I don't quite know what motivation leads somebody to do that. So I don't have an answer for you, other than to say you've raised a question that I think many people have raised, and maybe none of it ended up mattering at all in the end. But it is a little bit unusual. I'm happy to weigh in on the substance too, but if you want.
I actually just have a question on that last point. So could they, now that cert's been granted, don't they need agreement from all of the parties, including the individual respondents, to dismiss it?
No, you can unilaterally dismiss. You just need to agree to pay costs or something. You have complete control as a petitioner to always dismiss your case all the way up through. So yeah, the timing is such. I think the case is being argued before. It'd be really hard to actually have a change because of the timing of when it's going to be heard. Mm-hmm. So it's probably unlikely that that's what happens, even if but that's, the court deals with this every, these issues happen a lot when you have an administration change, and you kind of got to figure out, because you've got the lame duck period. If the new administration's saying, look, we're going to scrap this the moment we get in, do you still go ahead with argument just because you happen to schedule it for 2 days before inauguration instead of after? So it's a funky dynamic that, if Trump wins the election, we'll just have to see how that plays out.
So
just one more note on that, which is that they did calendar for December and not November, even though they could have put it on the November calendar, which means it's a few weeks after the election rather than a few days before. But again, it's after the election, before inauguration, so I don't know how that helps with anything. Anyway, go ahead, Mike.
I was just going to say, on the question about the chief and Gorsuch, I am not going to make any predictions about where they'll end up here. My recollection, and correct me if I'm wrong, was that in Bostock, they had sort of dropped a footnote that reserved constitutional questions. So they've reserved constitutional questions, and I don't know that they're going to feel necessarily bound by the Bostock opinion. I do think that there is an argument that you may find more or less compelling, depending on where you sit, that as a matter of sort of logic, the same reason why Bostock came out the way it did should argue for heightened scrutiny here. And we'll see at the argument how persuasive those justices and others find that argument.
Yeah, I mean, there's both an argument that Bostock's a statutory decision and doesn't control constitutionally. I think there's even in our own briefing on this issue, and I think there's a powerful argument that you can take Bostock on its own terms and it just doesn't apply here because Bostock is about, when you kind of have complete similarly situated individuals and this is different, and there's this whole, to me, these cases are all about how you view that threshold question of, is it the same thing when you're providing this surgery to a biological male versus biological female? Is it the same thing to give testosterone to a biological male versus biological female? I think that framing question is what leads, you think yes, you go one direction, you think no, you go the other direction. And I think that actually ends up being more important than the debate about, kind of whether the reasoning of Bostock applies outside the concept of the statute and in the Equal Protection Clause. But that's just, my own thoughts from how I've approached it in my own cases where I've been litigating it.
All right. It's now 6:30.
Oh, goodness.
Food and drinks. So we're going to adjourn. If you have questions, you're welcome to come up and speak with the panelists. Just go down the stairs and out the door to the left to get to the reception. And I'd like to end by just welcoming you to join me